I think you better go out. I'm going to pass it briefly. You need to go out and check your client.
Oh, no, Judge.
No, go out and check your client.
I will, Judge.
What you're about to watch is not a simple eviction hearing. This is a procedural tug-of-war spanning multiple courts, multiple counties, and years of unresolved legal tension. At the center of this case is a property caught in what attorneys call a global settlement, but what that really means is everyone believes another court should decide first. The plaintiff wants the eviction to finally move forward. The defense insists this case is still legally frozen because Wayne County Circuit Court hasn't closed the file, and standing between them is Judge Simpson, trying to untangle jurisdiction, authority, and timing without overstepping another court's power. This is where courtroom drama gets real, because this isn't about shouting or theatrics, it's about procedure, about whether a judge can issue an eviction order with conditions, even when another court may still hold the keys. You'll hear repeated references to stays, rights, jurisdiction, and appellate, history. You'll see frustration boil over. You'll hear a litigant crack under the weight of years of delay. And the biggest question driving everything, if a case is technically open somewhere else, can this court still act? Watch closely, because the answer isn't as simple as either side wants it to be.
Patrick Tatura versus Martin Youngs.
Do you need the seat?
No, he won't be staying long.
I hope that's the case, Judge.
Me too.
Good morning, Your Honor. May it please the court, Eric Wadowski, 65354 on behalf of plaintiffs.
Good morning, Darwin Fair, defendant P number 31266.
The plaintiff filed a motion to lift the stay and enter an order of eviction. At the time, I had not received a response, but I thought I wasn't sure where other proceedings were. I realized what was represented in the motion. And so I set this for hearing. So.
Well, Judge, I hope we would not be here today. We've been down this road a number of times, and your question is always the same question, and the answer is always the same answer, which is the Wayne County Circuit Court has not closed the file. There's still pending actions in front of the Wayne County Circuit Court that impact on the issue that's before this court.
This is the defense's core argument, and they repeat it relentlessly for a reason. As long as Wayne County hasn't closed its file, they argue this court should not move forward. In legal terms, they're saying jurisdiction hasn't fully shifted back. Notice Judge Simpson's reaction. He immediately pushes back by questioning relevance. The property is in Washington County, so why should Wayne County control this eviction? That's not irritation. That's a judge testing the legal logic. He's asking, is this a real jurisdictional barrier or just a delaying tactic? The defense responds by invoking the phrase global settlement. That phrase carries weight, but it's also vague. Judges don't rule on vibes. They rule on authority. And right now, Judge Simpson hasn't seen the settlement itself. That matters. This back and forth shows how procedural arguments can stall real-world consequences like eviction for years. It also foreshadows why the judge starts exploring conditional relief later.
So, unless we're here to argue the Wayne County Circuit Court motion, I don't know what more to say to the judge. There's really nothing more to say.
This property is located in Washtenaw County, however.
Where's it?
Yes, it is, Your Honor.
Sure.
Yeah,
Yes.
the property is in Washtenaw, so I'm not clear why I'm worried about anything being litigated in Wayne County.
Well, what happened?
Let me rephrase that. I don't know why I would be worried about that with reference to this active proceeding forth in the eviction happening.
Well, the reason, Judge, is for the same reasons that occurred multiple times before this court, which is the property in Washtenaw County is subject to a settlement agreement that was entered into with the Wayne County Circuit Court judge. So this is part and parcel of this global settlement. And the reality of it is that this case on this property is still subject to the jurisdiction of the Wayne County Circuit Court judge as has been the case every time we get before this court. As every time we get before this court, it's the same issue, Judge. And now this is, I will admit, this is the first time I've heard the court say this, but the reality is still the reality. This property is part of, and Judge, I know you do not want me to repeat myself, and I don't like to repeat myself, but I'm a little concerned that if this is not being gotten across, is every time we get to come to court, it's because of the same issues of this global settlement that is before the Wayne County Circuit Court judge.
Well, no. Before I would, right. I mean, the reason the case is here is for whatever its reasons. But part of the reason that things were stayed is because clearly it was headed up the chain, the appellate chain.
Here's where appellate history enters the picture. The defense explains that earlier appeals justified the stay, but now those appeals are gone. That weakens their position. A stay isn't permanent. Once the appellate path ends, trial courts regain authority unless another legal barrier exists. Judge Simpson is doing something subtle but powerful here. He's reframing the issue. Instead of asking why shouldn't I act, he starts asking why can't I act with conditions. That's a judge looking for a solution instead of a stalemate. This is where experience shows. Judges know that refusing to rule indefinitely creates injustice of its own, so he floats a compromise. Issue the eviction order, delay its execution, and allow Wayne County to intervene if needed. Engagement question. Is this a fair middle ground, or does it unfairly pressure the defense?
My understanding is that's no longer the case.
No. And let me
know that.
No, that's not the case. And so let me explain it this way, Judge, because I'm trying to get into your head. What the court, I think, is concerned about is the Washtenaw County Circuit Court case that directly impact this case. And that case, the Washtenaw County Circuit Court case, which was appealed to the Michigan Court of Appeals.
Right.
Okay, that case was dismissed, Judge, as a result of a global settlement that is before the Wayne County Circuit Court judge. So what happens in this case is still being handled by the Wayne County Circuit Court judge because the Washtenaw County case, which was appealed to the Michigan Court of Appeals, was voluntarily dismissed as a result of the settlement.
Let me cut to the chase. Why wouldn't I just lift my stay, issue the order of eviction, allow it to be executed at some future time, that they couldn't do it right away?
This is the turning point of the hearing. Judge Simpson lays out a practical roadmap. He's saying, I can act without causing harm. Issue the order, delay enforcement, and give the defense time to seek protection from Wayne County. Legally, this is sound. Eviction orders don't automatically mean someone is thrown out the next day. Execution matters. By separating the order from enforcement, the court preserves balance. The defense, however, pushes back hard, not on legality, but on history. They argue this exact scenario has failed before. Hearings get adjourned, decisions get delayed, and meanwhile, the eviction order hangs over their heads like a loaded weapon. This is less about law now and more about trust. The defense doesn't trust the process to move quickly. The judge doesn't trust indefinite delay.
Allow it to be executed at some future time. And if you're correct, then get a stay from Wayne County.
Okay, well, Judge, okay, now, and I'm hearing you, and I'll walk down that road with you. So the issue of the quote unquote eviction is a function of the ownership of the subject property. The ownership of the subject property is specifically before the Wayne County Circuit Court judge. So let's assume that the court says, okay, I mean, enough's enough, although it's the same issue that has been before this court multiple times, and the court says the same thing multiple times, which is, I'm not going to do anything until the Wayne County Circuit Court has made a decision, which is what, okay.
I don't know that I said anything about Wayne County.
No,
I think I said something about Washtenaw County and the Court of Appeals and the Supreme Court.
No, No,
Go ahead.
no. It's never about the Washington County. It's always about Wayne County. It's always about Wayne County. It's never about Washington County, because Washington County, Judge, again, was appealed to the Michigan Court of Appeals. It was voluntarily dismissed as a result of the global settlement that was before Wayne County Circuit Court. Judge.
And Mr. Fair, I'm saying, let's assume for the sake of argument that you're correct. I have a feeling there's going to be disagreement as to what you're saying in part. But why then wouldn't I just grant the relief, issue the order, and then you get a stay of that and allow an opportunity, so I wouldn't have it where it could be executed immediately, give you an opportunity to then get before the Wayne County Circuit Court, which you're saying this property is part of some global settlement, and allow that court to basically stay any order of eviction or enjoin the plaintiffs in this case from moving forward.
Okay, Judge, allow me to walk down that road. Okay, so
why is that a hard question? I don't need to be walked down the road. Why is that a difficult question to answer?
Because the hearing, no. Because the hearing that you're making reference to, that I should go before the Wayne County Circuit Court judge and ask for a stay, is a hearing that is essentially scheduled for July the 18th.
Dates matter in court, and this one is doing heavy lifting. July 18th becomes the defense's shield, proof that Wayne County will address the issue soon. But Judge Simpson counters with statutory structure. Even after a hearing, eviction law builds in waiting periods. He references the 10-day statutory window. That's not arbitrary. It's designed to prevent immediate displacement. By anchoring his ruling to that timeline, the judge is showing restraint, not aggression. This exchange highlights a truth most viewers never see. Judges are constantly balancing speed and fairness. Move too fast, you risk injustice. Move too slow, you deny relief entirely.
That hearing will address the very point this court is making. So
then why don't I grant the relief, indicate that the writ cannot be executed until, if your hearing's on the 28th of July,
no, 18th.
That it can't be executed until the 28th of July, giving the 10-day statutory period from the time of that hearing.
Okay, Judge, this is the road we always walk down, because what happens is on the 18th, we don't know what Judge Ewell will do. Judge Ewell may say, I'm not going to hear it on the 18th. Or, and Judge, I'm only going by what's happened in the past, and it's safe.
You're going to have to leave. You're going to have to leave.
This is where emotion finally breaks through procedure. Tensions spike, voices overlap, and the judge draws a hard line. Courtrooms are structured environments. When order breaks down, judges intervene immediately. What's striking is that this moment isn't about disrespect alone. It's about control. Judge Simpson is signaling that emotional arguments won't override legal analysis. And yet, moments later, he does allow the party to speak. Carefully, that contrast matters. It shows judicial authority paired with restraint. The court isn't silencing pain, it's demanding structure. Engagement question: should judges allow emotional outbursts in cases involving homes and families? Or does order have to come first?
I do not want to argue, Judge.
Go ahead.
Case. So what has happened in the past, which is probably what's going to happen today, is that on the 18th, Judge Ewell will do one of two things, which has happened in the past. When this issue is before this court, Judge Ewell may or may not hear the case on the 18th, or may hear the case on the 18th and then decide not to make a decision until sometime in the future. Now, again, Judge, I'm not saying this for the first time. This has been the history of this case. Now, if we look at what happened here, they filed a motion to go before the Wayne County Circuit Court judge. And it was scheduled for the following Friday. At the same time, they filed this motion in front of you and filed a motion in front of the 35th District Court, assuming that the Wayne County Circuit Court judge would close the file. Because I will tell you, Judge, the question that you always ask, this is the question you always ask: what's the status of the Wayne County Circuit Court case? Is it open or is it closed? The answer is always the same. It's open. Your response is always the same. Well, I'm not going to do anything until the Wayne County Circuit Court makes a decision. And then a couple of times, Judge, you said, I'm going to adjourn it to right after when the circuit court judge makes a decision.
So why don't I put an end to that and just grant their relief?
Well, because, Judge.
Because it doesn't leave you, Mr. Fair, without remedy. Because you can always ask the Wayne County Circuit Court, as I've said, to either stay that writ if they've taken some jurisdiction over this property, or to enjoin the defendants from proceeding on the writ that I would issue.
Well, Judge, this is a conversation we've had at nauseam all the time. And
well, I'm trying to end it.
And what I think but I think, Judge, what you recognize is, well, that means I've got to run to the Wayne County Circuit, the Wayne County Circuit Court, ask for a stay. The judge is going to say, aren't we going to be hearing this on the 18th? And then on the 18th, like what has happened in the past.
Well, hold on a second. No, you wouldn't have to do that if you would listen to what I'm saying. What I'm saying is I could grant the plaintiff's relief. They could not do anything. And I'm not even saying on the 18th. I'm saying for a 10-day period after that hearing. So if the judge at that point in Wayne County doesn't do anything, the 10-day statutory period would begin to run on the writ.
Wait a minute, if he, wait, Judge. Okay, so the motion that is before the Wayne County Circuit Court, which plaintiff acknowledges affects what this court can do. What they're asking the Wayne County Circuit Court is close the case, close it. Mm-hmm. And then if it's closed, then they can come to you and say, hey, Judge, it's closed. So let's go back to that point. On the 18th, if the judge does not close it, if the judge does what he has done in the past. If the
judge does not close it, you could request of the judge to enjoin the plaintiffs from proceeding forward. If the judge does close it, the writ would proceed.
Well,
that seems really simple to me.
The 10 days after that.
Right, 10 days after.
But that means a couple things. Number one, if I'm hearing the court is saying, well, if it gets adjourned to August the 10th, August the 18th, another month. And if at that time, the judge closes it, that means in this interim period between July the 18th and August the 18th, by definition, they can't do anything.
No. I'm not saying that.
Okay.
What I'm saying is, you're saying the Wayne County Circuit Court has that this is part of some global resolution.
Correct.
Okay, I'll take you at your word for that. I've not seen the resolution. That's fine. It doesn't matter to me. What I am saying is, I will assume you to be correct. I will assume also that Judge Ewell will act within his authority regarding any agreement there is. Right?
Correct.
So if I grant the plaintiff's relief, built into that are enough protections for the defendant in terms of being able to request of Judge Ewell to enjoin the plaintiffs from acting. If that case is going to be adjourned out or he doesn't rule on that day.
Well, okay, Judge. And I'm not gonna belabor the point. I'm gonna put the past in the past because we've always in this situation and your position is real simple. Is it open or closed? If it's closed, if it's
No,
open.
no. The question is it pending or not?
Okay.
So if the
still pending.
issue, no, Mr.
Yeah.
Franklin, if the issue before this court is pending somewhere elsewhere,
Correct.
that is always what I will address.
Correct.
And I think properly so. It doesn't sound like that's what's happening here. It sounds to me, based upon what you're saying, and again, I haven't seen it, that there is some resolution of this global resolution, whatever it is. I'm saying, fine. There are still issues to be decided with that. They don't need to be decided here. And so that I could grant the relief that the plaintiff requests with enough safeguards that protect the defendant until whatever that issue to be resolved is.
Well, if the court is saying that the plaintiff in this case cannot act upon any decisions of this court pending.
That is not what I am saying. That is not what I'm saying, and you know that's not what I'm saying.
Can I ask you a question? Judge, my client wants to ask a question. You can say yes.
Go ahead.
Go ahead.
I mean, we did everything. It seems like we get penalized every time, not in your court so much, but we do everything. We had a global settlement.
This is the emotional core of the case, and it hits hard. After years of procedural sparring, the defendant finally speaks. And what you hear isn't legal theory, it's exhaustion. 7 years, multiple properties, a settlement everyone thought was finished. And yet, here they are, facing eviction anyway. Legally, emotional testimony doesn't override jurisdictional rules, but practically, judges listen because credibility, history, and fairness all matter. What this speaker is expressing is the human cost of unresolved litigation. Delays aren't neutral. They affect housing stability, finances, and family life. Judge Simpson's response is crucial. He doesn't dismiss the pain, but he redirects it back to structure. Courts don't resolve global fairness. They resolve specific legal authority. And this property, right now, is sitting at the intersection of two courts that haven't finished coordinating. Engagement question. After 7 years of litigation, should courts prioritize finality over procedural perfection?
3 pieces of property, 1 in Washtenaw, 2 in Wayne County. We all signed, the lawyers all signed what had to be done to get that done. We do everything in the agreement. My family, everything in agreement. They refused to sign a paper, and we're here. And we're getting penalized by getting an eviction. No matter how you rule it, it's against us. Whether we settle something on the 18th or not. We're not supposed to even be here. This is a pending case in Wayne County Court that we all agreed to settle. That guy has the ruling. I don't know what we're even here for.
You, like your attorney, are not listening to me.
You're
I
saying you're
take
gonna
you
rule
at, if
and
you
give
want to
them their way.
interrupt me, then you go right ahead.
No, I'm sorry. It's just, I've done everything for 7 years. I've worked up in this, and I've got, his client has jerked me around for 7 years. Well, and I haven't been able to live in a house I built. And then I'm gonna get an eviction notice that I know doesn't mean anything to you guys, but to my family, it means everything.
Sir, maybe you and your attorney should listen to what the court is proposing to do. Because both of you have been saying the same thing, that there is this agreement out there that is subject to the jurisdiction of the Wayne County Circuit Court. I'm not going to even begin to get involved in that.
Right. If you're, can I say one thing? I'm sorry, I'll leave.
No.
He doesn't get it.
Judge didn't say.
He's always been good, but
Judge didn't say
I gotta get out of here before I have a breakdown, man.
Yeah, Judge didn't say you couldn't say it, so why don't you say it?
All I am saying is there is this agreement. I've not read this agreement. I don't know what this agreement is per se. in terms of how the court is ruling. Not even in a lot of ways have detailed specifics about what needs to be decided. Maybe the issues, sir, that you're raising need to be decided. What I'm saying is, as to this property, if indeed that's going to be decided in Wayne County as part of this agreement, I'm going to issue the order. I would issue the order of eviction, subject to the date that your next hearing is, and giving enough time so that your interest in regard to that settlement can be protected by Mr. Fair. That's all I am saying. I'm not ruling that there's going to be an eviction. I'm not ruling any of that.
This line is subtle but critical. Judge Simpson is clarifying the misconception that issuing an order equals immediate eviction. It doesn't. An order sets legal posture. Execution determines real-world impact. What the judge is doing here is preserving flexibility. He's not deciding ownership. He's not invalidating the settlement. He's creating a procedural bridge that allows this court to act without foreclosing relief elsewhere. This is how experienced judges manage overlapping jurisdiction, by issuing conditional rulings that can be paused, stayed, or enjoined if another court steps in. It's not indecision, it's layered authority. The frustration in the room comes from misunderstanding that nuance. To the parties, an eviction order feels final. To the court, it's provisional.
Then why rule at all?
Because it's my job.
Okay.
Sit down.
Sorry.
Judge, can we rest at this point, and then I have a rebuttal after you speak to brother counsel? You know,
He needs to get out.
yeah. Well, yeah.
I think you better go out. I'm going to pass it briefly. You
Whoa.
need to go out and check your client.
Oh no, Judge.
No, go out and check your client.
I will, Judge. But he's fine.
Court recalls the case of the Totoro versus,
Good morning again, Your Honor. Eric Ladat on behalf of the plaintiff.
Good morning, Your Honor. And Your Honor, Darwin Fair on behalf of, and Your Honor, if I may, if I could just make one last statement, give brother counsel an opportunity to talk. I can give just a little.
Go ahead.
So, all right, Judge. Plaintiff counsel knows the posture. It's based upon what's happened in the past. So they filed a motion to close the case because that is the question, Judge, you always ask, and you wouldn't rule because of the circuit court.
This explanation fills in the procedural chessboard. Plaintiff's counsel anticipated Judge Simpson's threshold question, is the Wayne County case closed? And tried to force that answer in advance. When it didn't happen, everything collapsed into confusion. What we're seeing is misaligned timing. Motions filed on assumptions instead of rulings. Hearings scheduled based on predictions. And when those predictions fail, trial courts are left holding unresolved disputes. This reinforces why Judge Simpson keeps returning to the same standard, pending or not pending. Courts don't operate on expectation. They operate on record.
So they filed a motion in front of the Wayne County Circuit Court asking that the case be closed. And that was up for hearing a Friday ago. Well, we've been down this road before about a notice of hearing and a precipice. So the precipice wasn't accepted. But at the same time they filed the motion, Judge, they thought or presupposed on that day the judge would rule in their favor. And so at the same time, they filed motions for eviction in this court and also 35th District Court. Well, we both were alerted that the Wayne County Circuit Court was not going to hear the Wayne County Circuit Court case when they had noticed it for hearing. And I was notified by plaintiff counsel that, well, I'll let you know when the precipice is accepted, which means the hearings before this court had to be pushed off until after the Wayne County Circuit Court made a decision. So that is where the breakdown occurred, because then the Wayne County Circuit Court accepted the precipice for the 18th. And so initially the thinking was, well, let's just adjourn this case until after the 18th. I reminded Brother Counsel, we've been down this road a million times. What happens is whatever date that the Wayne County Circuit Court comes up with, oftentimes either doesn't occur, or if it does occur, the proverbial can gets kicked down the road. Then there was a breakdown, because at that point, Brother Counsel says, well, let's just go with the hearing, even though this hearing was initially scheduled because it presupposed the Wayne County Circuit Court would make a decision before we got before this court. And so that's why my initial argument for the court was, I don't know why we're here. So, Judge, I would like to defer any further argument unless the court has questions after Brother
I have
Counsel.
no questions. Counsel?
I have no objections, Your Honor, to the court entering the order of eviction, but not allowing its perfection until after July 28th.
Court, having heard argument on this case, the plaintiff's motion to lift the stay to the extent that there was one and enter an order of eviction is granted. A writ of or an order of eviction may issue, but here's how I'm going to do it. I'm going to issue it with a firm date of August 1st, 2025 or thereafter. The 56-day rule on the issuance of a order of eviction is waived by the court.
Here is the ruling, and it's far more measured than it may sound. Judge Simpson grants the motion but builds in multiple safeguards. The eviction order is issued, yes, but execution is delayed. The 56-day rule is waived only to create clarity, not urgency. By setting August 1st, the court ensures the defense has time to seek relief from Wayne County. That's the key. This ruling doesn't override another court. It invites coordination. Legally, this is a conditional enforcement order. Practically, it forces movement. The case can no longer sit in limbo. Someone, somewhere, must decide. Engagement question. Is this decisive leadership, irrefight or unnecessary pressure?
That, and so that the record is clear, that should give enough time should the defendants wish to seek other relief before the Wayne County Circuit Court. They may do so, and it is a period after the hearing, and actually it would extend the period out originally contemplated by the court. Regarding the 10 days, it extends it out a little bit more than that. So, all right, thank you.
Thanks, Judge. Always a pleasure.
Prepare the order.
I need you to prepare it.
Yes, Your Honor. Perfect.
Thank you.
Judge, can we put this on the record that I need to see the order before it gets signed, because Brother Counsel has a habit of sending orders that I have.
You know what? I'm not going to be between the counsel. Go out there, get a form order. You guys fill it out, approve it before you leave my building.
Sounds like a plan.
Yes, Your Honor.
This case was never just about eviction. It was about jurisdiction, timing, and accountability across courts. Judge Simpson made it clear, indefinite delay is not an option. At the same time, he respected the authority of Wayne County to resolve the broader settlement issues. The final ruling strikes a balance, granting relief while protecting the defendant's right to seek further court intervention. Whether that intervention succeeds now depends on what happens next in Wayne County. This is how complex civil litigation often ends, not with a dramatic gavel slam, but with a carefully structured order designed to force resolution without injustice. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.